Before we begin, a quick and important disclaimer. The following video explores the intersection of marital breakdown, digital education platforms, and socioeconomic trends within the framework of American social studies. This content is created strictly for educational, historical, and entertainment purposes. It does not constitute legal, financial, psychological, or relationship advice. The phenomena discussed involve complex sociological data and case studies that may not apply to every individual circumstance. Viewers are strongly encouraged to conduct their own due diligence and consult with licensed professionals, such as family law attorneys or certified financial planners, regarding their personal situations. Every single day in the United States, roughly 2,000 marriages come to an end. It is a quiet, standard statistic of American life that we have grown completely numb to. But beneath the surface of these court filings lies a multi-billion-dollar shadow economy that the average person knows absolutely nothing about. In recent years, a bizarre and highly polarizing digital phenomenon has taken over the internet, known colloquially as the Divorce University Online. These are not traditional academic institutions. They are high-ticket digital platforms, private forums, and algorithmic ecosystems where thousands of Americans are paying massive premiums to study the mechanics of marital dissolution like a competitive sport. We are witnessing a cultural shift where the end of a legal union is no longer treated merely as a private family tragedy, but as a complex administrative, strategic, and financial battlefield that requires advanced training. Some view these platforms as essential toolkits for survival in an adversarial legal system, while others view them as predatory institutions weaponizing domestic strife for digital profit. This brings us to a critical question within modern American social studies. How did the breakdown of the nuclear family become a gamified, monetized, and outsourced digital curriculum? If you are watching this in America today, this deep dive solves a massive, hidden problem that impacts our collective social fabric. Navigating the modern landscape of relationship breakdown, asset division, and legal bureaucracy has become so overwhelmingly complex that the traditional institutional safety nets are failing. By contextualizing the rise of the online divorce university, you will understand the exact economic incentives, psychological triggers, and technological shifts that are reshaping American households. You will learn how to look past the sensationalized internet marketing and analyze the real-world case studies, historical trends, and potential outcomes of this digital shift. Whether you are analyzing this as a student of sociology, a professional navigating the changing legal landscape, or someone trying to understand the modern digital economy, this masterclass will dismantle the mechanics of how the internet fundamentally rewired the way America deconstructs its households. To truly understand how we arrived at the era of the online divorce university, we must first trace the historical trajectory of marital dissolution in American society. Throughout the 19th and early 20th centuries, getting a divorce in the United States required a formal showing of fault. A spouse had to prove specific egregious wrongdoings, such as abandonment, cruelty, or adultery, in a public court of law. This legal structure meant that the dissolution of a marriage was rare, deeply stigmatized, and incredibly difficult to achieve. The entire socioeconomic framework of the country was designed to keep the family unit intact at all costs, primarily because the household was the foundational economic building block of the nation. This framework shifted dramatically in 1969 when California passed the Family Law Act, signed by then-Governor Ronald Reagan, which introduced the concept of no-fault divorce to the United States. For the first time, a couple could dissolve their marriage based simply on irreconcilable differences, without the need to assign blame or publicly parade private grievances in a courtroom. By the 1980s, the vast majority of American states had adopted some form of no-fault legislation. Sociologists tracking historical trends noted a massive, immediate spike in the national divorce rate during this period. The legal barrier had been lowered, and the social stigma began to erode. However, while no-fault legislation simplified the ideological reason for ending a marriage, it did not simplify the logistical, financial, or administrative reality of doing so. As the decades progressed, the division of marital property became infinitely more complex. In the mid-20th century, marital assets typically consisted of a primary residence, a single vehicle, and a traditional bank account. Today, a modern American household often possesses a highly intricate portfolio of assets, including employer-sponsored retirement accounts like 401ks, stock options, health savings accounts, digital assets, and complex mortgage structures. Because the legal and financial stakes became so incredibly high, the traditional family court system evolved into a dense bureaucratic maze. The average cost of a contested legal separation in the United States climbed into tens of thousands of dollars, driven largely by hourly billable rates for attorneys, forensic accountants, and mediators. This economic reality created a massive accessibility gap. The wealthy could afford elite representation to navigate the system, while the working and middle classes were often left to navigate a hostile, confusing legal environment completely on their own, frequently resulting in devastating financial outcomes. This accessibility gap is the exact point of origin for the modern online divorce university. Whenever a traditional institution becomes too expensive, too confusing, or too gatekept for the general public, the internet steps in to democratize, decentralize, and monetize that information. In the early 2000s, this took the form of basic internet forums and self-help blogs where individuals would share PDFs of local court forms and exchange peer-to-peer advice. But as the creator economy matured and digital course platforms expanded in the 2010s and 2020s, these informal forums underwent a massive commercial evolution. Entrepreneurs, former litigants, and contrarian legal professionals realized that there was a massive market for structured, premium educational content focused entirely on the strategy of marital split-ups. They began packaging information into comprehensive digital masterclasses, complete with video modules, downloadable worksheets, community message boards, and coaching calls. These platforms began to market themselves not just as informational sites, but as elite digital academies where a subscriber could learn the hidden rules of the family court system. When we analyze these platforms through the lens of social studies, we see that they rely on specific, highly effective psychological and sociological mechanisms to attract their student base. The primary driver is the mitigation of acute vulnerability. A person going through a domestic split is often experiencing one of the most stressful periods of their human existence. They are facing the potential loss of their children, their home, and their future financial stability. In this state of profound uncertainty, the traditional legal system offers very few emotional or strategic assurances. Attorneys charge by the minute and are explicitly trained to remain detached and analytical. The online divorce university fills this emotional and structural void. It promises structure in the midst of chaos. The curriculum is deliberately designed to make the user feel like they are regaining control of their destiny. Modules are broken down into step-by-step phases, such as auditing marital assets, managing communication with an ex-spouse to avoid triggering legal liabilities, and preparing for judicial mediation. By transforming a chaotic, emotionally draining life event into a series of structured, intellectual tasks, these platforms provide a powerful psychological coping mechanism for the modern consumer. To fully grasp how these online programs transform a deeply personal crisis into a strategic curriculum, we must analyze the specific mechanics of their digital architecture. This is not just about watching a few videos on a web browser. The modern online divorce university operates as a sophisticated, multi-tiered educational ecosystem that mimics the structure of elite digital business schools. When a user enrolls, they are typically introduced to a highly organized learning management system that categorizes the entire collapse of a human relationship into specific, actionable modules. Imagine a scenario involving an average American citizen named John, living in Ohio in the current year of 2026. John is a mid-level project manager who suddenly finds himself facing a highly contested separation. He has no legal background, his stress levels are at an all-time high, and the traditional legal consultations he has attended cost hundreds of dollars per hour just to explain basic terminology. When John logs into an online divorce platform, the chaotic reality of his life is instantly categorized into neat, manageable steps. Module 1 covers digital forensic auditing of household expenses. Module 2 breaks down the socio-legal history of custodial rights in the Midwest. Module 3 provides interactive spreadsheets to map out asset distribution according to local statutes. By restructuring a highly emotional event into a series of technical tasks, the platform alters John's psychological approach to his situation. He ceases to view himself merely as a grieving spouse and begins to view himself as a data-driven strategist. This shift in perspective is exactly what keeps users engaged for hours at a time, driving up retention rates on these platforms. The curriculum actively gamifies the administrative process. Users track their progress through completion percentages, unlock advanced modules on cross-examination tactics after finishing foundational legal theory courses, and download templates designed to optimize their communication with legal counsel. However, the educational experience extends far beyond pre-recorded video modules. The true core of the online divorce university model lies in its peer-to-peer community infrastructure. These platforms frequently feature private, heavily moderated digital forums and messaging channels where thousands of individuals going through similar life transitions interact daily. In these digital spaces, social dynamics shift rapidly. The forums function as a decentralized crowdsourcing engine where users post redacted copies of their court filings, share specific behavioral patterns of opposing counsels, and analyze local judicial tendencies based on historical trends in specific jurisdictions. Consider a case study from a major digital community that specialized in navigating high-conflict separations in 2025. Within this forum, members actively track the specific rulings of family court judges across various counties in Texas. By aggregating the collective experiences of hundreds of local users, the community constructed an informal database detailing which judges historically favored specific mediation styles, or which magistrates were more stringent regarding the valuation of small business assets. This type of crowdsourced intelligence is something that a traditional law firm rarely provides in a structured format to a standard client, illustrating why the perceived value of these online academies has skyrocketed among the American public. Yet, this democratization of information introduces significant sociological risks that social studies researchers are actively documenting in 2026. When complex legal and financial strategies are disseminated in a peer-to-peer environment without the direct oversight of licensed, localized professionals, the potential for misinformation rises exponentially. A strategy that yielded positive potential outcomes in a specific community property state like California could result in catastrophic financial liability if applied blindly by someone like John in an equitable distribution state like Ohio. The algorithms governing these platforms are designed to maximize engagement, which means highly dramatic, aggressive, or contrarian strategic advice often receives the most visibility within the user forums, creating a feedback loop that can escalate domestic conflicts rather than resolving them. This brings us to the underlying economic model of these institutions. The monetization strategy of the online divorce university is highly sophisticated, utilizing value ladders that mirror the broader digital creator economy. The initial entry point is often low-cost or entirely free educational content distributed via social media algorithms. This content typically highlights the structural flaws of the traditional family court system, emphasizing how standard legal processes can drain an individual's life savings. Once a user is integrated into this informational funnel, they are introduced to mid-tier offerings, such as specific masterclasses ranging from $200 to $500. For the most deeply invested users, the platform unlocks high-ticket tiers, which include private group coaching, direct access to specialized strategists, and proprietary software tools designed to analyze financial disclosure documents. This economic structure has turned the online divorce university into a massive growth industry within the broader landscape of American digital commerce. It thrives precisely because it positions itself as a cost-saving alternative to traditional legal fees, arguing that an educated consumer will spend significantly fewer billable hours relying on an attorney to explain basic concepts. To understand the broader implications of this trend, we have to look at how it alters the traditional power dynamic between a client and their legal representation. Historically, the attorney held absolute informational authority. The client simply provided the facts of their life, and the professional translated those facts into the esoteric language of the court. Today, an individual armed with a comprehensive digital curriculum enters their attorney's office with a pre-constructed strategy, specific statutory citations, and an aggressive expectation of how their case should be managed. This has created a modern tension in the American legal ecosystem, where family law practitioners frequently find themselves competing with or correcting the crowdsourced education their clients receive online. The rise of these platforms is a direct reflection of a society that has normalized the outsourcing of personal development and crisis management to digital networks. We use online platforms to learn how to code, how to invest, and how to build businesses, so it was statistically inevitable that the American public would eventually utilize the exact same digital infrastructure to learn how to dismantle their marriages. This is no longer an isolated subculture. It is a mainstream component of modern American social studies that reveals how deeply technology has penetrated our most intimate institutional frameworks. But what happens when these online universities stop being just educational tools and start actively shaping the actual outcomes of real-world court cases? What happens when the strategies taught in these digital academies clash directly with the established traditions of the American judiciary? The intersection of digital strategy and systemic legal reality is creating a massive friction point that is changing the face of domestic relations across the United States. As thousands of heavily coached, strategically trained self-litigants stream into family courts nationwide, the entire judicial system is facing an unprecedented disruption. Judges are now forced to contend with an influx of individuals who speak the technical language of the law, but lack the institutional constraints of a licensed professional. How are courts reacting to this army of digitally educated litigants? And what does this mean for the future stability of American households? The answer to that question exposes an even deeper, more controversial layer of this digital phenomenon that changes everything we thought we knew about modern family dynamics. The institutional reaction to the rise of the online divorce university has been nothing short of a systemic shock to the American judiciary. To understand the gravity of this shift in 2026, we have to look at the traditional courtroom as a highly regulated ecosystem that relies on a specific set of unwritten rules and professional courtesies. For over a century, the family court system in the United States operated on the assumption that both parties would be represented by licensed attorneys who acted as officers of the court. These attorneys served as filters, translating the raw, often irrational emotions of their clients into structured legal arguments that fit within the narrow confines of state statutes. But the emergence of the digitally trained self-litigant has bypassed these filters entirely, creating a friction point that is redefining the very nature of legal proceedings. Imagine a courtroom in suburban Florida today. A character named Sarah, a small business owner who has spent the last 6 months immersed in an intensive online divorce curriculum, is standing before a judge. Unlike the self-represented litigants of the past who often appeared confused, overwhelmed, and unprepared, Sarah is armed with a color-coded binder of exhibits, a tablet preloaded with relevant case law, and a foundational understanding of the rules of evidence that she learned from a module titled Advanced Courtroom Presence for Non-Attorneys. When the opposing counsel, a veteran family law attorney, attempts to introduce a hearsay statement, Sarah stands up and issues a timely objection based on the specific subsection of the state evidence code. This scenario is becoming increasingly common across the country. In this masterclass of modern social studies, we must identify this as the pro se professionalization trend. It is a phenomenon where the line between a layperson and a legal professional begins to blur due to the high-velocity transfer of specialized knowledge via digital platforms. While this might seem like a positive democratization of the law, the judicial response has been deeply nuanced and, in many cases, highly resistant. Judges are finding that while these litigants are more informed, they often lack the situational awareness and ethical constraints that come with a formal legal education. A digital course can teach you the definition of a deposition, but it cannot easily teach you the decades of local judicial temperament and the subtle art of negotiation that prevents a case from spiraling into a 5-year war of attrition. Historical trends indicate that when a system is flooded with high information, high-intensity participants who operate outside the traditional guild, the system often tightens its requirements. We are seeing some jurisdictions respond by implementing mandatory pre-filing orientations or more stringent digital filing requirements that essentially act as a barrier to those who are purely self-taught. However, the online divorce universities are already 3 steps ahead, releasing updated modules on how to navigate these new bureaucratic hurdles. This creates a perpetual arms race between the judicial establishment and the digital education sector. Let us look at a case study from the Pacific Northwest involving a group of litigants who utilized a specific online platform to challenge the valuation methods of pension plans during domestic settlements. Historically, pension valuation was an area of such dense mathematical complexity that most individuals simply deferred to whatever number the court-appointed expert provided. However, the online university provided these individuals with specialized software and forensic accounting tutorials. By the time they reached the hearing stage, they were able to challenge the experts on technical grounds, such as the specific discount rates used in present value calculations. The potential outcomes of this case study were significant. It led to a more equitable distribution of long-term assets for the individuals involved, but it also resulted in much longer, more adversarial court dates that strained the local county's resources. This brings us to a critical economic tension. The American legal system is built on the billable hour, whereas the online divorce university is built on the flat-fee digital product. These two economic models are fundamentally at odds. If a digital course costing $500 can effectively replace 20 hours of an attorney's time at $400 per hour, the traditional law firm faces a massive disruption to its revenue model. In response, some forward-thinking law firms in 2026 have begun to pivot, offering unbundled legal services or coaching sessions specifically for individuals who are already enrolled in these digital academies. They are moving from being the sole pilots of the legal ship to acting more like air traffic controllers for the self-educated litigant. But we must dig deeper into the actual content being taught in these digital halls. One of the most controversial aspects of the online divorce university is the focus on strategic psychological mapping. Many of these platforms go far beyond legal forms and financial spreadsheets. They dive into the tactical management of the ex-spouse's behavior. This is often taught through the lens of high-conflict personality theory. Students are taught how to communicate in a way that is strictly informative, neutral, and brief, often referred to in these circles as the gray rock method or parallel parenting frameworks. By teaching individuals how to systematically de-escalate or strategically document every interaction, these platforms are essentially providing a manual for domestic psychological warfare. In a social studies context, this represents a shift from the family unit as a site of emotional negotiation to a site of strategic risk management. The goal is no longer necessarily a peaceful resolution, but a documented one. The software tools provided by these universities often include integrated messaging apps that timestamp every communication, track the location of child exchanges, and record the sentiment of text messages to be used as future evidence. This level of surveillance and documentation, while arguably necessary in high-conflict scenarios, changes the fundamental nature of the post-divorce family. It creates a digital panopticon where every word spoken or typed is viewed through the lens of its potential impact on a future court filing. We are witnessing the birth of the algorithmic family, where human relationships are managed by the same data-driven principles used in corporate supply chains. To analyze the broader societal impact, we must consider the data being generated by these platforms. The largest online divorce universities in 2026 are sitting on massive datasets regarding domestic conflict, asset distribution patterns, and judicial behavior. In the tech world, data is the new oil, and these platforms are arguably the most sophisticated refineries of domestic data in existence. There is a high probability that this data will eventually be used to train artificial intelligence models that can predict the outcome of a divorce before the first paper is even filed. Imagine an AI tool that analyzes your financial history, your spouse's social media activity, and your local judge's past rulings to give you a percentage-based probability of your potential outcomes. This is not science fiction. It is the logical conclusion of the digital education trend we are currently observing. As we move into the next phase of this masterclass, we have to look at the dark side of this technological integration. While these universities empower many, they also create a new form of digital divide. What happens to the individuals who cannot afford the high-ticket digital courses? What happens when one spouse is armed with a $5,000 strategic curriculum, and the other is relying on a public defender or a basic internet search? The disparity in digital literacy is creating a new hierarchy in American family law, one where the outcome of a case is determined not just by the facts or the law, but by who has the better digital training and the more advanced strategic software. This imbalance is triggering a quiet crisis in the American legal landscape, leading to a new wave of regulations and ethical debates that are currently tearing through state legislatures. The rise of the digital divorce strategist is not just a trend in education. It is a fundamental reconfiguration of power that is about to hit a massive, unavoidable wall of institutional pushback. What happens when the state decides that these online universities are practicing law without a license? The looming legal battle over the very existence of these platforms is the next frontier in this deep dive. The tension between the unauthorized practice of law and the constitutional right to access information is the primary fault line upon which these digital institutions currently sit. In the United States, the legal profession is one of the most strictly regulated guilds in existence. Each state has a bar association that maintains a monopoly on legal advice, a term that is often broadly defined as the application of legal principles to a specific set of facts. For decades, this definition was the shield that protected traditional law firms from digital disruption. However, the online divorce university has found a sophisticated workaround by branding its entire output as educational curriculum rather than legal counsel. In this part of our masterclass, we have to analyze the high-stakes legal tug-of-war occurring in 2026 as state regulators attempt to pull the plug on these digital giants. Imagine a character named Michael, an entrepreneur in Silicon Valley, who launched one of the most successful online divorce academies in the country. In early 2026, Michael receives a cease and desist order from a state bar committee. The committee argues that by providing interactive calculators that suggest specific alimony amounts based on user input, the platform is no longer merely teaching social studies or law, it is practicing law. Michael's defense, which mirrors real-world historical trends in the tech industry, is that his platform is a modern printing press. He argues that he is simply selling a very expensive, very interactive textbook. This distinction is not just a semantic game. It is the difference between a multi-million-dollar tech company and a criminal enterprise. To understand why this matters to the average American viewer, we must look at the concept of the legal desert. According to data tracked by sociological researchers, over 80% of low-income Americans and a staggering 60% of middle-income households do not have access to affordable legal services for civil matters like domestic relations. In many rural counties across the United States, there may only be 1 or 2 family law attorneys for every 10,000 residents. This creates a vacuum. When the state attempts to shut down an online divorce university, they are essentially telling millions of people in these legal deserts that their only option is to navigate a life-altering crisis with zero guidance. This has led to a significant public backlash, where the users of these platforms are becoming political activists, petitioning for a deregulation of the legal industry to allow for these digital alternatives. The battle over the unauthorized practice of law is not just happening in boardrooms. It is manifesting in the actual user interface of the platforms. To avoid prosecution, many online divorce universities have implemented what sociologists call defensive design. When a user like Sarah or John from our previous examples logs in, they are met with a gauntlet of digital disclaimers. Every lesson, every spreadsheet, and every video module is preceded by a statement clarifying that this is for informational purposes only. But here is where it gets fascinating from a social studies perspective. The more the platforms add these disclaimers, the more the users view them as rebellious, counterculture institutions. There is a psychological phenomenon where the state's attempt to regulate a service only increases its perceived value in the eyes of a frustrated public. Let us look at a specific case study from 2025 involving a digital platform that utilized a sophisticated decision tree algorithm to help users draft their own parenting plans. The state bar argued that the algorithm was essentially performing the work of a paralegal or an attorney. The platform countered by showing that the algorithm was based entirely on public domain statutes, and that the user was the one making every final selection. This case, which is still rippling through the 2026 legal landscape, highlights a massive loophole. If an AI or an algorithm provides the information, who is the one practicing law? Can a line of code be arrested for practicing law without a license? As these universities integrate more advanced generative technology, the traditional definitions of legal practice are beginning to dissolve in real time. Furthermore, we must analyze the role of the instructors within these universities. Many of these platforms are not founded by lawyers, but by individuals who have personally navigated the family court system and found it lacking. They call themselves strategists or consultants. In the eyes of the American social fabric, these individuals are becoming a new class of professional. They are the digital equivalent of a tribal elder or a community navigator. They speak the language of the people, not the language of the ivory tower. They use metaphors involving sports, business, or military strategy to explain the adversarial nature of court. This pedagogical style is much more effective for the average American than a dry legal brief. It resonates with a culture that values self-reliance and the democratization of knowledge. However, the risk of this model is that it often lacks the ethical guardrails inherent in the traditional legal system. An attorney is bound by a code of professional responsibility that includes an obligation to promote the best interests of children and to avoid frivolous litigation. A digital platform driven by subscription metrics and user engagement may inadvertently prioritize high-conflict strategies because they are more exciting and keep the user logged in longer. Historical trends in social media algorithms show that conflict generates more clicks than resolution. If an online divorce university focuses its curriculum on how to maximize the collection of evidence or how to outmaneuver an opponent, it could potentially escalate domestic situations that might have otherwise been settled through a simple mediation. This brings us to the hidden economic impact on the children of the American household. Within our social studies framework, the family is the primary institution for socialization. When that institution breaks down through a highly clinical, strategically aggressive digital lens, the potential outcomes for the next generation change. We are seeing a trend where children are increasingly being treated as assets or liabilities in a digital ledger. The software tools provided by some of these universities allow parents to track every minute of visitation with a precision that was previously reserved for professional athletes or corporate logistics. While this provides a high degree of accountability, it also introduces a level of surveillance that can permanently alter the parent-child dynamic. Despite these risks, the demand for these platforms shows no signs of slowing down in 2026. The cost of living in the United States, combined with the rising price of traditional professional services, has made the online divorce university an economic necessity for many. It is a symptom of a much larger shift in American society. The move toward a do-it-yourself infrastructure. We are seeing this in medicine with biohacking communities, in finance with decentralized crypto networks, and now in the legal system with digital academies. The common thread is a deep-seated distrust of traditional institutions and a belief that a well-informed individual with a high-speed internet connection can perform the tasks that were once reserved for a specialized elite. But the most dangerous part of this entire phenomenon is not the legal battle or the economic disruption. It is something much more subtle and much more pervasive. It involves the data. As these universities collect the most intimate details of millions of American lives, their finances, their parenting struggles, their private communications, they are creating a repository of information that is more valuable than any social media profile. Who owns this data? How is it being used to influence future legislation? And most importantly, what happens when this data is leaked or sold? We are entering an era where your most private family failures are being converted into a digital asset class. And the next layer of this investigation reveals exactly how that data is being weaponized in ways that will make you rethink every digital form you have ever signed. We have to look at the shadow brokers of the divorce industry, and the revelation is chilling. To understand the sheer scale of how personal data has been transformed into an asset class within the divorce industry, we have to look behind the clean, empathetic user interfaces of these online universities and examine the architecture of the data brokers operating in 2026. When an individual inputs their information into a digital platform, they are not just filling out forms. They are constructing a highly detailed, real-time psychological and financial profile. This profile tracks assets, hidden debts, emotional vulnerabilities, parenting friction points, and communication frequencies. In the broader context of American social studies, this represents the ultimate commodification of domestic life, where the collapse of a household generates a stream of behavioral data that is highly sought after by third-party industries. Imagine a character named Emily, living in Michigan in the current year of 2026. Emily decides to utilize a mid-tier online divorce platform to help her organize her financial declarations. She uploads bank statements, tags specific household expenses, and answers algorithmic questionnaires about her lifestyle, her children's extracurricular schedules, and her current employment status. What Emily does not realize is that the moment she clicks submit, her aggregated, de-identified data enters a sophisticated secondary market. While the platform's privacy policy states that her individual identity is protected, her behavioral patterns are highly predictable and incredibly valuable. Data brokers categorize individuals like Emily into hyper-targeted consumer segments, such as transitional heads of households or high-stress solitary consumers. Once categorized, this data is utilized by a vast web of industries looking to capitalize on the exact moment a household splits. For example, local real estate firms purchase predictive data to identify individuals who will likely need to downsize or list a primary residence within the next 90 days. Moving companies, storage facility operators, subscription-based therapy services, and automotive dealerships all bid on these data streams. They understand that a person navigating a domestic split is about to completely reconfigure their entire consumer behavior pattern, spending thousands of dollars to establish a new, independent life. This data monetization is analyzed by sociologists as a structural shift in how corporate America interacts with the broken nuclear family. Historically, businesses had to rely on public records, such as newly filed court dockets, to identify individuals undergoing a life transition. By the time a case hit the public record, it was often too late for targeted marketing campaigns. Today, the Online Divorce University acts as an early warning system for the market. It captures the consumer at the point of intent, weeks or even months before any official paperwork is stamped by a county clerk. The financial value of this early intent data is immense. creating a hidden revenue stream that allows these online academies to subsidize their low-cost entry tiers while maximizing their overall profitability. Let us look at a case study involving a major digital tracking network that partner platforms utilize throughout 2025. This network analyzed the metadata of over 50,000 users who were actively progressing through online legal modules. The historical trends derived from this data showed a direct correlation between the completion of asset auditing modules and an immediate 40% spike in searches for short-term apartment leases and independent credit card applications. By tracking the chronological steps of the digital curriculum, external corporations could predict with startling accuracy exactly when a user would transition from the planning phase to the execution phase of their household separation. The potential outcomes of this tracking are a highly efficient, hyper-targeted advertising ecosystem that captures the consumer when they are at their most economically volatile. However, the weaponization of this data extends far beyond targeted advertising for consumer goods. The most alarming development in 2026 is how this data is being reintegrated into the actual legal conflict itself. In high-stakes domestic disputes, digital forensics has become the primary battleground. If one spouse is utilizing an online divorce university and accessing its community forums from a shared household device or a synchronized network, they leave a digital footprint. Opposing counsels have begun issuing broad discovery requests that specifically target the browsing history, downloaded templates, and forum interactions of the other party on these educational sites. Consider a real-world scenario where a spouse's strategic curriculum is turned against them in court. A husband who has been systematically coached by an online forum to present a highly specific, low-conflict persona during mediation is blindsided when the opposing attorney introduces evidence of his active participation in a digital forum thread titled, "How to Minimize Appraised Business Value for Court." The internal search queries, the specific modules watched, and the redacted spreadsheets downloaded from the online university can be subpoenaed to demonstrate intent, premeditation, and strategic manipulation of assets. This completely dismantles the user's credibility before a judge, transforming their expensive digital education into a legal liability. This creates an intense paradox within modern American society. The very platforms designed to empower the citizen through the democratization of information are simultaneously creating a digital trail that can be weaponized by the institutional systems they are trying to bypass. The user is caught in a digital panopticon of their own making. To gain knowledge, they must surrender data. To utilize that knowledge, they must execute strategies that leave an indelible mark on the digital landscape. This reality has forced the top tier of online divorce universities to pivot toward privacy-focused architecture, charging premium fees for encrypted learning environments, burner accounts, and decentralized data storage that promises to shield the student from forensic discovery. Furthermore, we must examine the emergence of the algorithmic matching systems within these platforms. Many advanced online universities do not just sell courses. They use data analytics to match students with vetted, high-velocity family law attorneys or private investigators in their specific geographic region. The platform acts as a digital market maker, taking a percentage of the retainer fee as a referral commission. This creates a powerful economic incentive for the platform to guide the user toward a specific style of litigation. If a platform's data shows that a user is highly emotional and possesses significant marital assets, the algorithm may route them toward a highly aggressive, litigious attorney who is known for maximizing billable hours, rather than a peaceful mediator. This intersection of predictive data, corporate monetization, and legal matching is fundamentally changing the ethics of domestic relations across the United States. It raises a massive question about the true allegiance of these digital institutions. Are they truly public interest academies designed to save the American middle class from financial ruin? Or are they highly sophisticated data funnels designed to extract maximum value from the wreckage of human relationships? As we track the flow of dollars and data through this shadow economy, the lines between education, exploitation, and optimization become completely blurred. But the disruption does not stop at data brokers and corporate ad networks. There is an even larger structural transformation taking place that strikes at the core of the American financial system. The online divorce university has caught the attention of major Wall Street institutions, venture capital firms, and litigation finance corporations. They are beginning to view the aggregated data of these platforms as a tool to commodify the court system itself, turning individual domestic cases into a speculative asset class where investors can bet on the financial outcomes of divorces. How this new wave of predatory institutional capital is entering the family sphere is the next profound revelation in this masterclass, and it alters everything we understand about the future of wealth in America. The entry of major investment capital and speculative financing into the domestic relations ecosystem marks a profound inflection point in modern American social studies. Historically, the financial aftermath of a domestic split was contained strictly within the boundaries of the household and its immediate creditors. Wall Street viewed family law as a fragmented, unpredictable retail market, completely unsuited for institutional asset allocation. However, the rise of the online divorce university has entirely upended this calculation in the current year of 2026. By standardizing the legal and administrative process into predictable data points, these digital platforms have created a framework where institutional investors can treat household dissolution as a scalable, securitized marketplace. Imagine a scenario involving an elite investment firm based in Manhattan. The firm manages a specialized alternative asset fund dedicated entirely to consumer civil disputes. Through an API integration with a major online divorce platform, the fund's proprietary algorithms scan the aggregated financial disclosures and asset tracking modules of thousands of anonymous users. The algorithm identifies high-probability asset distributions, hidden corporate equity valuations, and unliquidated real estate holdings. Once a highly lucrative case is flagged, the fund offers what is known as consumer litigation funding directly to the user through the platform's interface. This is how the modern mechanics of third-party funding work inside the family sphere. Consider an average American named David, an engineer in Texas who owns a highly successful boutique software firm. David is facing a complex separation from his spouse, who is demanding an aggressive valuation of his company's intellectual property. David's liquid capital is tied up in business operations, making it impossible for him to match the massive retainers required by top-tier forensic accountants and trial attorneys. An institutional litigation funder steps in and reviews David's data profile on his online divorce platform. The fund agrees to advance David $50,000 to hire elite professional representation and build a robust valuation model. In exchange, the fund does not charge traditional interest. Instead, it purchases a contingency percentage of the final financial settlement. When we look at historical trends in alternative asset classes, we see that capital always flows toward areas of high friction and high transactional value. The online divorce university acts as the perfect origination pipeline for these investment firms. It strips away the emotional ambiguity of relationship breakdown and reduces the entire crisis into a cold, transactional balance sheet that an underwriting algorithm can evaluate in seconds. This has led to the emergence of what sociologists call the commodification of domestic equity, where the wealth built within an American marriage is no longer just split between two individuals, but sliced into yielding tranches for institutional shareholders. The systemic implications of this trend are vast and deeply disruptive to the traditional concept of American justice. When a hedge fund or a venture-backed litigation finance company owns a financial stake in the outcome of a household split, the entire incentive structure of the dispute shifts. In a standard scenario, both parties eventually face a point of economic exhaustion where the high cost of billable hours forces them to compromise, settle out of court, and move on with their lives. However, when an outside investor has subsidized the litigation expenses, that economic ceiling is completely removed. A funded litigant can afford to reject reasonable settlement offers and pursue aggressive, long-term court battles in an attempt to extract a larger payout. Let us analyze a case study from a major civil trial in California that concluded recently. The case involved a high-asset household where one party's legal strategy was completely funded by an anonymous institutional investor. The funding allowed the litigant to file hundreds of separate discovery motions, subpoena distant corporate affiliates, and hire 3 separate expert witnesses to contest the valuation of a single commercial property. The potential outcomes of this case study were devastating for the family court system. The trial dragged on for 18 months, longer than the state average, costing the county tens of thousands of dollars in administrative overhead and completely backing up the judge's docket for other local families who desperately needed hearings. The investor ultimately walked away with a massive return on their advanced capital, while the actual family unit was left emotionally shattered by a year and a half of continuous adversarial theater. This dynamic creates an intense philosophical debate within the social sciences. On one hand, proponents argue that litigation funding democratizes access to high-end legal strategies. It prevents a wealthy spouse from using financial starvation tactics to force a less affluent partner into accepting an unfair settlement. The Online Divorce University, by acting as the educational and digital broker for these funds, positions itself as a champion of economic equity. On the other hand, critics point out that this introduces a predatory element into an already volatile human crisis. An investment fund is bound by a fiduciary duty to maximize profit for its limited partners, not to look out for the psychological well-being of a fractured American household or the long-term stability of the children involved. Furthermore, we must examine the micro-level impact on how individual wealth is managed in anticipation of these trends. The realization that the online ecosystem can monetize and track domestic asset splits has led to a major shift in how the upper middle class structures its finances. We are seeing a historic rise in the use of domestic asset protection trusts, postnuptial agreements, and highly complex corporate structures designed explicitly to blindside the data mining algorithms of these online academies. The modern American household is increasingly being managed like a sovereign corporation, utilizing defensive financial architecture to shield its capital from both external market forces and internal relationship risks. This level of financialization is changing the very nature of what a marriage represents in the 21st century. Within American social studies, the institution of marriage was traditionally viewed as a social compact designed to foster community stability, emotional support, and generational wealth transfer. The rise of the Online Divorce University, paired with institutional capital, redefines it as a high-risk venture capital initiative. The household becomes an entity that can be strategically optimized, leveraged, audited, and liquidated by a network of digital algorithms, data brokers, and corporate financiers. As we follow this progression to its logical conclusion, a new and even more controversial layer of the digital divorce universe reveals itself. The monetization of relationship breakdown has become so profitable that it is no longer just attracting alternative hedge funds. It is actively reshaping the political and legislative landscape of the United States. These digital platforms and their financial backers are beginning to assemble massive lobbying coalitions to influence state family law codes, child support guidelines, and judicial appointment processes. They are moving from simply teaching the rules of the game to actively writing them. What happens when the laws governing the American family are subtly altered to ensure that the digital divorce industry stays permanently profitable? The next phase of this deep dive exposes the hidden political machine driving this algorithmic evolution, and the scope of its influence is truly staggering. The shift from a digital classroom to a political powerhouse is the most significant structural evolution in the modern American social landscape of 2026. To understand how an online educational platform can influence state-level legislation, we must examine the concept of the legislative industrial complex. In the United States, family law is primarily governed by state statutes rather than federal mandates. This decentralized system creates 50 distinct legal laboratories, each with its own set of rules regarding alimony, child custody, and property division. For the Online Divorce University, this fragmentation was initially a hurdle, but in recent years, it has become their greatest opportunity for growth and systemic control. Imagine a political strategist named Marcus, working for a consortium of digital legal education platforms and litigation finance firms. Marcus is tasked with identifying states where the current legal codes are either too vague or too outdated to accommodate high-velocity digital litigation. He focuses on a battleground state like Pennsylvania. Through a well-funded lobbying arm, Marcus's organization begins to draft model legislation that prioritizes the use of automated dispute resolution, digital mediation, and mandatory standardized financial disclosure forms. On the surface, these reforms are presented to the public as a way to increase efficiency and lower costs for the average taxpayer. However, a deeper analysis reveals that these standardized digital forms are designed to be perfectly compatible with the proprietary software and data mining algorithms owned by the Online Divorce Universities. This is the manifestation of what sociologists call algorithmic lobbying. By influencing the very forms and procedures that the court requires, these platforms are ensuring that their curriculum remains the essential gateway to the legal system. If a state adopts a new, complex digital filing requirement, the online university immediately releases a paid module teaching users how to navigate it, creating a self-sustaining cycle of legislative change and educational monetization. Historical trends in American industries, from the healthcare sector to the tax preparation industry, show that corporations often lobby for increased complexity in the law to ensure that their services remain indispensable to the public. the scope of this political influence extends to the judicial selection process itself. In many American states, judges are elected or appointed through a highly political process. Political action committees associated with the digital divorce industry are now contributing significant amounts to judicial campaigns. Their goal is to support candidates who are technologically progressive and open to the use of AI-driven evidence or third-party litigation funding. This creates a judicial environment that is increasingly hospitable to the strategies taught within the online academies. When a judge is comfortable with a litigant using a decentralized forensic audit tool, instead of a court-appointed accountant, the value of the online university's curriculum increases exponentially. Let us look at a case study from a legislative session in the American South in 2025. A coalition of digital platforms successfully lobbied for a bill that incentivized the use of private, digital-only arbitration for marital assets below a certain financial threshold. The potential outcomes of this legislation were multifaceted. While it did clear thousands of cases from the backlogged public court system, it moved those cases into private, digital forums where the public has no oversight and where the rules of procedure are dictated by the terms of service of the platform. This represents a historic privatization of the American justice system, where the constitutional right to a day in court is being traded for the convenience of a digital dashboard. Furthermore, we must analyze the role of child support guidelines in this political maneuvering. Child support in the United States is typically calculated using rigid mathematical formulas that vary by state. The online divorce university industry has begun advocating for reforms that would shift these formulas toward more data-intensive models. By including more variables, such as real-time tracking of parenting time or fluctuating gig economy income, the system becomes more accurate, but also significantly more difficult for a layperson to manage without professional software. This ensures that the subscription to the digital academy becomes a long-term necessity, extending far beyond the initial separation and into the decades of co-parenting that follow. Consider a scenario involving a character named Robert, a freelance graphic designer in 2026 who has a highly variable monthly income. Under the new, digitally influenced laws in his state, Robert is required to update his financial data in a state-linked portal every 90 days. To do this accurately and protect himself from legal sanctions, Robert relies on a recurring subscription to an online divorce university's compliance module. The platform has successfully turned a one-time life crisis into a 20-year recurring revenue stream by influencing the state's reporting requirements. This is the ultimate goal of the political machine: to embed the digital platform into the very fabric of the citizen's ongoing relationship with the state. The impact on the American social fabric is profound. We are moving toward a tiered system of justice where the law is increasingly written for the benefit of those who can navigate high-tech interfaces. This creates a new form of disenfranchisement for those who lack digital literacy or the financial means to keep up with the evolving curriculum. Sociological researchers are documenting a growing gap in parental rights and asset retention that correlates directly with the level of digital education a litigant has received. The law is no longer a static set of principles. It is a dynamic, high-velocity stream of updates that requires constant monitoring. This political evolution also triggers a reaction from the traditional legal establishment. The American Bar Association and various state bar units have begun their own counter-lobbying efforts. They argue that the privatization of domestic law threatens the integrity of the family unit and undermines the ethical protections that only a licensed attorney can provide. This has led to a series of high-profile legislative battles across the country, where the traditional guilds are clashing with the digital disruptors. These battles are not just about who gets to practice law. They are about the fundamental definition of the family in the eyes of the state. As these platforms gain more political leverage, they are also expanding their reach into the international arena. The American model of the online divorce university is currently being exported to other common law jurisdictions, such as Canada, the United Kingdom, and Australia. By standardizing the digital approach to relationship breakdown, these corporations are attempting to create a global infrastructure for domestic dissolution. The data being harvested from American households is being used to refine the algorithms that will eventually manage families worldwide. But there is an even more intimate layer to this political and technological shift that we have yet to explore. It involves the way these platforms are utilizing the principles of behavioral economics to influence the personal decisions of their users. It is one thing to teach someone the law. It is another thing entirely to use psychological nudges and algorithmic feedback loops to steer them toward specific life choices that benefit the platform's bottom line. The next part of this deep dive examines the dark art of algorithmic persuasion within the divorce university and how it is subtly rewriting the emotional code of the American family. The revelation of how your own psychology is being mapped and manipulated is the most personal chapter of this investigation yet. The integration of behavioral economics into the online divorce university is not merely a side effect of digital learning. It is a fundamental design choice intended to optimize the user's decision-making process toward specific, high-value pathways. In the realm of American social studies, this is referred to as choice architecture. By subtly nudging a user toward certain emotional or strategic responses, these platforms are effectively rewriting the internal logic of the domestic split. They use the same psychological triggers found in social media apps and high-frequency trading platforms to manage the most volatile period of a human being's life. Imagine a character named Jennifer, a marketing executive in Chicago in 2026. Jennifer is using an elite online divorce platform that features a dashboard equipped with a mood-tracking algorithm. Every time Jennifer logs in to check her legal documents, the platform asks her a series of rapid-fire questions about her current emotional state. This data is not just for her self-reflection. The algorithm analyzes her responses to detect signs of decision fatigue, anger, or extreme vulnerability. If the system detects that Jennifer is feeling particularly vengeful after a contentious weekend of co-parenting, it might present her with a high-intensity module on aggressive asset discovery rather than a peaceful mediation guide. This is a personalized nudge, steering her toward a more complex, data-heavy legal path that requires longer engagement with the platform's premium tools. Historical trends in behavioral science show that human beings are highly susceptible to loss aversion, especially during times of crisis. Online divorce universities weaponize this by framing every legal or financial decision as a choice between total victory and total loss. Instead of presenting a settlement as a neutral compromise, the curriculum often uses terminology that emphasizes what a user might lose if they do not follow a specific strategic protocol. This creates a state of heightened alertness, ensuring that the user remains tethered to the platform for constant reassurance and tactical updates. The potential outcomes of this psychological mapping are individuals who are more informed, yes, but also more hypervigilant and less willing to engage in the informal, flexible negotiations that traditionally helped families resolve conflicts without scorched earth litigation. Let us look at a case study from a 2025 pilot program conducted by a Silicon Valley tech firm that specialized in digital conflict resolution. The firm utilized A/B testing on two groups of users. Group A received neutral, fact-based legal information regarding child support. Group B received the same information but packaged with social proof notifications, such as 85% of successful users in your area utilize this specific document filing strategy. The results were definitive. Group B was 3 times more likely to purchase advanced software add-ons and spent twice as much time interacting with the community forums. This demonstrates that the online divorce university is no longer just a place to learn. It is a laboratory for behavioral modification where social pressure and algorithmic nudges dictate the pace of a household's dissolution. The strategic use of variable rewards is another pillar of this psychological architecture. In the world of social studies, we see this most clearly in the gamification of the litigation process. Users earn badges or level up as they complete complex financial disclosures or successfully serve legal papers to their spouse. This provides a dopaminergic hit in an otherwise bleak and depressing environment. By transforming a legal burden into a digital accomplishment, the platform keeps the user coming back. However, the dark side of this gamification is that it can trivialize the gravity of the life decisions being made. When a user is focused on checking off boxes and earning digital accolades, they may lose sight of the long-term emotional impact their aggressive tactics are having on their children or their future co-parenting relationship. Furthermore, we must examine the concept of the feedback loop within the university's community ecosystem. These platforms often feature ranking systems for forum contributors, where the most active and often the most controversial voices are elevated to the status of moderator or mentor. This creates an echo chamber where moderate, conciliatory advice is drowned out by high-stakes strategic rhetoric. If Jennifer in Chicago seeks advice on a small disagreement regarding a holiday schedule, the algorithm is more likely to show her a thread where a top-ranked mentor suggests that this small disagreement is actually a tactical move by her ex-spouse to undermine her custodial rights. This algorithmic bias toward conflict escalation ensures higher platform retention, as high-conflict cases require significantly more digital resources and professional referrals. Consider a scenario involving a character named Thomas, a retired military officer in 2026. Thomas is highly disciplined and values structured protocols. The online university he subscribes to recognizes this through his interaction patterns and serves him a curriculum that emphasizes tactical dominance and procedural rigidity. The platform uses a nudge known as the anchoring effect, where it presents him with extreme case studies of successful outcomes in high-asset disputes. By setting these high-stakes stories as the anchor, the platform makes Thomas's actual, more modest settlement options feel like a failure. This psychological anchoring pushes Thomas to reject reasonable offers and continue a protracted legal battle, which in turn fuels the platform's data sets and referral commissions. This level of behavioral engineering is leading to a new sociological phenomenon known as the algorithmic escalation of domestic conflict. Because the digital environment thrives on high-intensity interaction, it inadvertently creates a culture where peace is viewed as a lack of strategy. The online divorce university doesn't just teach the law, it teaches a mindset of perpetual competition. This is a profound shift for American society, which has historically relied on the court as a place of last resort. Now, the digital academy makes the adversarial process the primary mode of operation, long before a judge is ever involved. As we analyze the impact on the American household, we have to ask, who is responsible for the psychological health of the student? A traditional law school or a bar-certified attorney has an ethical obligation to avoid causing unnecessary harm. A digital platform, however, is governed by the laws of the attention economy. If a user's anger leads to more clicks, more course completions, and more software upgrades, the platform has a hidden economic incentive to keep that user in a state of strategic agitation. This is the ultimate ethical crisis of the 2026 digital legal landscape. But the most disturbing aspect of this psychological mapping isn't what happens while you are on the platform. It's what happens after you leave. The behavioral data collected during your most vulnerable moments doesn't just vanish. It is being used to create a permanent digital score that could follow you into your next relationship, your next job application, or your next insurance quote. The realization that your divorce university performance is being used to judge your future stability is the hidden trapdoor in this entire ecosystem. And as we move toward the final sections of this masterclass, we are going to look at the emergence of the domestic reputation score and how your behavior during a split is being permanentized in the cloud. The age of the private family crisis is officially over, and the era of the social credit of domestic relations has begun. What you do in the digital courtroom today will determine your freedom tomorrow. The emergence of the domestic reputation score represents the ultimate integration of algorithmic monitoring and social credit concepts within the American family infrastructure of 2026. Within the scope of American social studies, we have long analyzed how financial credit scores, pioneered by the Fair Isaac Corporation in the late 20th century, completely reconfigured a citizen's access to housing, transportation, and economic mobility. What we are witnessing today is the logical digital extension of that exact same structural control mechanism, moving out of the purely financial realm and directly into the domain of interpersonal conduct and household compliance. The online divorce university has inadvertently become the primary laboratory for this development, acting as the software engine that aggregates behavioral data and archives it for institutional evaluation. Imagine a character named Amanda, a healthcare administrator living in Virginia in the current year of 2026. Amanda has recently completed a 2-year post-separation tracking curriculum managed by a prominent online digital academy. Throughout this period, every single interaction she had with her former spouse, every financial modification she made to her household budget, and every minute of variation in her custody handoffs was recorded, timestamped, and analyzed by the platform's integrated family management software. Amanda viewed this as a protective measure to ensure her compliance with local court orders. However, when she applies for a premier corporate position at a major national health network, she finds that the background screening process has evolved dramatically. The corporate background check firm utilized by the network does not just pull Amanda's criminal records and traditional financial credit history. In 2026, specialized data aggregators have begun purchasing predictive behavioral metadata directly from the parent corporations of online divorce platforms. These aggregators construct a proprietary metric known colloquially as a domestic stability rating or a household risk index. The algorithm scans Amanda's historic data, analyzing things like her communication sentiment scores, her frequency of procedural disputes, and her level of adherence to automated digital mediation schedules. If the algorithm flags Amanda as a high-conflict individual based on her digital footprint during her domestic split, her overall score drops. The potential outcomes of this score reduction are catastrophic. She is quietly flagged as a potential interpersonal liability in the workplace, and her application is automatically filtered out by the employer's hiring software. This case study is not an isolated malfunction of technology. It is an emerging historical trend within the broader landscape of the American data economy. Whenever an industry standardizes a once chaotic human process, the resulting data is inevitably commodified to mitigate risk for other large institutions. The banking sector, the insurance industry, and major corporate employers are all deeply invested in finding ways to predict human stability, reliability, and emotional resilience. A person's performance during the high-stress environment of a family dissolution is viewed by data scientists as the ultimate stress test. How you behave when your family structure is being dismantled is seen as highly predictive of how you will behave under corporate pressure, how likely you are to default on a high-value loan, or how much risk you present to a healthcare insurance pool. The mechanics of this domestic rating system operate through a web of data handoffs that occur entirely beneath the surface of the standard internet user experience. When a student interacts with the community forums, downloads a legal strategy worksheet, or logs a co-parenting event inside an online university app, that data is structured into a standardized behavioral profile. Advanced machine learning models train on this data to identify hidden markers of high-risk human behavior. For example, an individual who consistently logs communication entries at 2 o'clock in the morning, or who frequently uses highly charged language that requires automated moderation by the forum's AI, is categorized into a specific behavioral risk bucket. These risk buckets are then sold to secondary data brokers who merge them with traditional public records, utility bill histories, and consumer purchasing data. The result is a comprehensive, multidimensional profile that treats human relationships as a predictable mathematical equation. In a social studies context, this represents a fundamental erosion of the boundary between the private sphere and the public market. The home, which was historically viewed as a sanctuary from the clinical optimization of the marketplace, has been completely opened up to algorithmic surveillance. Every argument, every negotiation, and every compromise is converted into a data point that can influence a citizen's broader socioeconomic freedom. Furthermore, we must examine how the insurance industry is actively preparing to utilize these domestic risk profiles in 2026. Actuarial tables are built entirely on the calculation of risk and the prediction of future liabilities. Historical trends show that individuals undergoing a high-conflict household separation exhibit statistically higher rates of stress-related medical conditions, vehicular accidents, and workplace absenteeism. In response, automotive and health insurance corporations have begun exploring pilot programs that incorporate these household stability ratings into their underwriting models. A user who was heavily involved in a protracted, hostile digital litigation strategy, as tracked by their online university metrics, could see their insurance premium rates adjusted upward based on the statistical probability of elevated behavioral risk. The online divorce universities find themselves in an incredibly lucrative position within this new ecosystem. They are no longer just educational platforms selling videos for a flat fee. They are the primary gatekeepers of the most valuable behavioral data stream in the country. This has led to a structural shift in their business models, where the true customer is no longer the individual student navigating a separation, but the institutional enterprise customer purchasing the aggregated data insights. This creates a deep systemic conflict of interest. The platform's interface is designed to feel like a safe, supportive space for self-education and community healing, but the backend is a hyper-efficient data extraction machine that converts human vulnerability into corporate capital. This level of permanent digital tracking introduces a terrifying concept known as the permanent record of personal failure. In the pre-digital era, the mistakes made during a difficult life transition were eventually forgotten. The files sat in a dusty basement of a county courthouse, inaccessible to the average observer. Once the legal proceedings were over, an individual could move to a new town, start a new relationship, and effectively reinvent themselves. Today, the algorithmic memory of the cloud ensures that your past behavior is permanently attached to your digital identity. The strategy you used to navigate a custody dispute in your 20s can be retrieved and analyzed by an algorithm when you are trying to buy a house in your 40s. This reality alters the way Americans approach relationships from the very beginning. We are seeing the rise of a hyper-calculating, risk-averse generation that views marriage not as an emotional milestone, but as a high-stakes legal contract that must be managed with extreme procedural caution from day one. The rise of the online divorce university has normalized the idea that relationships are cyclical, mechanical, and inherently temporary structures that require continuous algorithmic auditing. But as the entire infrastructure of American domestic life becomes fully digitized, audited, and rated, we are about to hit the final, most explosive realization of this entire investigation. What happens when the algorithms stop just tracking your behavior and start actively deciding whether you are even allowed to form a family in the first place? The ultimate convergence of artificial intelligence, state control, and the digital divorce industry is about to create a system that will completely redefine the concept of human freedom in the Western world. The final chapter of this masterclass exposes the blueprint for the automated future of human relationships, and it is a reality that is already unfolding all around us. The transition from a system that records human failure to one that predicts and preempts it marks the final stage of the digital divorce university's evolution in American social studies. By the year 2026, we are moving beyond the era where individuals simply use the internet to navigate the end of a marriage. We are entering the era of the predictive domestic contract, where the data-driven lessons of the online university are being applied to the very beginning of human unions. This is the blueprint for the automated future of relationships, a system where the state and the marketplace collaborate to ensure that human domestic life is as predictable and low risk as a corporate merger. Imagine a character named Kevin, a software engineer in Seattle in 2026. Kevin is entering a new committed relationship and is considering marriage. Before he even proposes, his financial advisor and his insurance provider suggest that he utilize a relationship auditing platform, a specialized offshoot of the major online divorce universities. This platform doesn't just provide educational videos. It requires both Kevin and his partner to synchronize their digital identities. The algorithm analyzes their combined domestic stability ratings, their historical conflict data, and their financial compatibility scores. Based on these historical trends, the platform generates a predictive marital risk assessment. In this automated future, the state begins to offer incentives for those who agree to these digital audits. We are seeing legislative proposals in several American states that would offer reduced marriage license fees or preferential tax treatment for couples who complete a premarital digital curriculum and agree to a smart contract prenuptial agreement. These smart contracts are managed by the same infrastructure developed by online divorce universities. If the marriage should ever reach a specific, data-defined threshold of conflict or financial instability, the smart contract automatically triggers a tiered mediation process, bypassing the traditional court system entirely. This is not just about convenience, it is about the systemic automation of social stability. The sociological impact of this shift cannot be overstated. We are witnessing the birth of the algorithmic prenup. Historically, prenuptial agreements were reserved for the ultra-wealthy, viewed as unromantic and adversarial by the general public. However, by 2026, the online divorce university has successfully rebranded these agreements as a form of high-tech domestic planning. By providing affordable, templated, and algorithmically generated contracts, they have normalized the idea that every American marriage should have an exit strategy preloaded into its digital framework. This changes the very nature of the marital promise, shifting it from a lifelong covenant to a renewable, performance-based service-level agreement. Let us look at a case study from a major tech-forward municipality in Colorado that began a pilot program in late 2025. The city integrated an online divorce university's dispute resolution software into its local family court portal. Couples who opted into this system agreed that in the event of a separation, their assets would be divided by a preset algorithm based on their real-time financial tracking throughout the marriage. The potential outcomes were striking. These cases were resolved in an average of 14 days, compared to the 18-month average for traditional litigation. However, the trade-off was a total loss of judicial discretion. The algorithm did not care about the emotional nuances of the relationship or the specific, non-monetary sacrifices made by one spouse. It only cared about the data inputs it had been tracking for years. This leads us to the concept of the social engineering of the American family. When the state and private digital platforms provide the tools to automate the end of a relationship, they are effectively shaping the behavior of the people within those relationships. If you know that your domestic stability rating is being monitored, and that your smart contract will trigger a specific financial penalty for certain behavioral markers, you will inevitably alter your conduct. This is the ultimate realization of choice architecture. The online divorce university has moved from being a teacher to being a silent governor of the American home. Furthermore, we must analyze the emergence of the AI-driven custodial oversight system. In 2026, for families that have transitioned through the online university's curriculum, the co-parenting phase is increasingly managed by autonomous agents. These AI mediators handle scheduling, expense reimbursement, and communication between former spouses. If an AI agent detects a pattern of high-conflict communication that violates the digital parenting plan, it can automatically log a violation with the court or adjust the domestic stability rating of the offending party. This creates a frictionless but highly surveilled environment for children, who are growing up in households where human disagreement is mediated by code. The economic implications of this automation are a complete reconfiguration of the legal profession. In this future, the role of the family law attorney is relegated to that of a high-level systems auditor. They no longer argue about who gets the house. They argue about the validity of the algorithm that decided who gets the house. The online divorce university has successfully commodified the law to such an extent that the human element is being squeezed out of the process in the name of efficiency and data integrity. This represents a historic transfer of power from the legal guild to the tech industry. As we conclude this deep dive masterclass, we must reflect on what has been lost in this transition. The online divorce university was born out of a genuine need for accessible information in a broken, expensive system. It empowered millions of Americans like John, Sarah, Jennifer, and Amanda to stand up for themselves in a courtroom. It provided a lifeline of knowledge when they were at their most vulnerable. But in its growth and its hunger for data, it has become a mirror of the very system it sought to disrupt, only more efficient, more pervasive, and more permanent. The context of the divorce university in American social studies is a story of the American spirit of self-reliance colliding with the global reality of algorithmic control. We have democratized the law, but at the cost of our domestic privacy. We have lowered the cost of litigation, but at the cost of our interpersonal agency. We have created a system where a person can navigate the most painful moment of their life with a smartphone in their hand and a curriculum in their ears, but they do so while being tracked by a network of brokers, insurers, and institutional investors. The automated future of human relationships is already unfolding. It is visible in the apps we use to communicate with our partners, the software we use to track our finances, and the digital courses we buy to understand our rights. The question for the American public in 2026 is no longer whether we can stop this digital transformation, but whether we can maintain our humanity within it. As the boundaries between our private lives and the digital marketplace continue to dissolve, the final lesson of the online divorce university is a sobering one. In the digital age, even your heartbreak is a data point, and even your healing is a transaction. But the story of the digital takeover of the American household has one final hidden chapter. Beyond the algorithms and the lobbyists, a new resistance is forming, a movement of individuals who are opting out of the digital tracking, deleting the apps, and returning to the analog foundations of community and kinship. They are finding ways to navigate the law without leaving a digital footprint, and their success is starting to trigger a massive security crackdown from the very platforms they are trying to escape. The battle for the soul of the private life is just beginning, and the next decade will determine if the home remains a sanctuary or becomes a satellite office of the digital state. The curtain is rising on the great disconnect, and you need to know how to survive it.